Hi, this is Ken Jarecke. Today I'm talking with lawyer Mickey Osterreicher. He's a great friend to the photography community, the press photography community, the gig economy community. He's a friend to all of us, and he's the official lawyer of the National Press Photographers Association. So I'm really excited to talk to him and get some information on what's happening out there. Hi, Mickey.
Hello, thanks for having me.
It's great to talk to you. So let's start off with how are you doing? How are you feeling?
Fortunately, I feel fine. A little stressed, like everybody else, just trying to deal with so many issues. It's often hard to switch gears, sometimes going from AB5 to copyright to access to, all these other issues, and they're all happening at once. But I don't think that I'm any better or worse off than anybody else. I've got a roof over my head and food and my wonderful wife. And we're both working at home. She's directing the photographers at the Buffalo News in her office upstairs, and I'm pulling my hair out down here downstairs. So we got plenty of room to each give each other space and do what we can.
Perfect. Close, but with elbow room.
Exactly.
Mickey, there's AB5 out of California. Let's just talk about that. What's the latest on that? It's not good news, I understand.
Well, it's not. We were very, very disappointed in the judge's decision. He denied our request for a preliminary injunction against the state being able to enforce those sections of AB5 that restrict photographers to 35 submissions and also restrict them from shooting video. And then he, a few minutes later, ended up dismissing of the complaint that we had brought in its entirety. So what that means is we have time to appeal, and we are deciding whether to do that. But whether we do it or not, what we were hoping for is that while the legislature decided to fix, amend, do whatever they were going to do to correct the inequities in AB5, that at least the state of California would not be able to enforce those sections, and therefore would give some photographers and other visual journalists and the people that were affected by it, writers as well, an opportunity to go back to do what they had been doing before AB5 took effect on the first of the year. We're finding that even before COVID-19, that so many of them were losing their clients, their opportunities. There were so many questions about this law and how it would be enforced that clients were shying away from hiring anyone that might fall under its definitions. And unfortunately now, where there would probably be opportunity to work covering COVID-19 and all the different aspects of this pandemic, they're precluded from doing that. So it's almost a double whammy. And even if we appeal, as I said, it's going to take just as much time to go through the appeals process, especially with the courts now closed, as it may take for the legislature to act. So it's really unfortunate that this judge just didn't get it. We've seen it before with other judges. I mean, the case that comes to mind is this was a copyright infringement case called Bramer v. Violet Hughes. Some of the photographers may remember that. It came out of Virginia, the Eastern District of Virginia, where this photograph was infringed upon. The photographer brought a copyright infringement suit, and the trial court got all four fair use factors wrong. Not one or two of the four, but all of them, and then threw in this, well, the person used it in good faith, which is not a factor at all. Fortunately, that case was appealed. We filed an amicus brief along with ASMP and a number of other groups, and the appellate court, the circuit court for the Fourth Circuit, reversed completely and basically told the judge what an idiot he was. So, just because a trial judge says something doesn't necessarily mean that he or she is right or wrong. And that's what appellate courts are for. And sometimes the appellate courts don't get it right either. And sometimes the Supreme Court doesn't get it right either, as in another terrible decision, as far as we're concerned, that came out today from the U.S. Supreme Court in Allen v. Cooper, where the state had taken Mr. Allen's video and used it, and he brought an infringement suit, and they claimed sovereign immunity. In other words, that the state was immune from being sued under a copyright infringement. And the Supreme Court said that Congress had no authority to create a certain section of the law that abrogated the state's rights. We've already been talking to folks, and hopefully Congress will go back to the table and get it right and pass a law that will protect people and enable them to enforce their copyright when the state infringes on their work. But again, with COVID-19, who knows when the things will ever get back to the point of normal as we knew it 10 days ago or 2 weeks ago, and get around to even being able to concentrate on amending that law.
So, Mickey, just to reiterate, the AB5, it's a California state law,
Right.
and it makes it hard for companies to hire freelancers, and the unintended consequences of that, it was probably, I would guess, designed to help or protect the freelance community and create staff positions at whatever businesses. But really, it's the unintended consequences of a badly written law that's keeping photographers from working.
Absolutely. I mean, the law originally, as they were looking at what they called the gig economy, was really made to protect Lyft and Uber drivers.
Right.
Possibly allow them to be unionized and get those protections. But as you said, the unintended consequences, the road to hell is paved with good intentions. So AB5 came out. They've got, as I said, those submission caps, which is an arbitrary number. I think it originally started at 25. We said that was ridiculous while the law was being drafted. And then all of a sudden they picked 35 as a number. But unfortunately, as we have pointed out a number of times, is that, you don't have to be a clairvoyant to see that the news industry, even before all of this started with the coronavirus, the news industry was laying people off, getting rid of photo staffs in particular, or going out of business altogether. This law was not going to force them to take somebody who freelanced and make them an employee. Aside from that, if there were people who want to be employees, most of the members of NPPA, when I became a member back in 1973, most of them were staffers. That's not the case in terms of our membership anymore, because those jobs have just gone away. So thinking that this bill was going to force people, at least in the news media industry, the publishing industry, to become employees, clearly was done by people who didn't understand our profession. And that's really unfortunate. It's just kind of putting them, as I've said, between a rock and a hard place. They don't have the ability to be staffers, and now they don't have the ability to freelance. And so they're looking as to what to do. The other part of it is there are a lot of people who, for whatever reason, don't want to be staffers. They're either worried that if they work for one company and that company folds, goes out of business, they're going to lose their job. So they want to diversify. The second one is, as we heard from so many people, they're taking care of children. They're taking care of elderly parents. They want a flexible schedule. They want to be able to take assignments or not take assignments, or set them up based on their schedule. And they really understand the upsides of, yeah, you work for an employer and hopefully you have the benefits of vacation and sick time and unemployment insurance and, a possible pension. But they've done that balancing between those benefits and the benefits of having freedom and the ability to decide for themselves when and where they're going to work. And that right now has been taken away from them, and they're not working at all, which is not helpful to anybody.
So the other side of that coin, it's not just the photographers. I mean, you have a director of photography right under your roof there, so you're very close to this. The photo editors want to work with freelancers as well because it gives them options as far as different styles and different locations and what have you.
Absolutely. And, there are times that your staff, as in this situation now with COVID-19, is stretched really thin and you can't burn them out. So you have the ability to use other people when there are things happening in locations that economically don't make sense to send the photographer that far away to get a picture that a freelancer could shoot easily and much more cost effectively. It's great to use them. We're not talking about situations where people were misclassified, where they were really employees but treated as freelancers. In other words, you have to come to work 5 days a week. You have to be here between the hours of 9 and 5. You have to do all these things. But we're still not calling you an employee. We're still calling. That's a completely different story and a misclassification and an abuse of the labor law. That's not what we're talking about here.
Yeah, I mean, the Department of Labor, we went through this probably 20 years ago with Time Magazine or the Time Life publications, where they gave us office space, they gave us insurance and stuff like that, although we were contract photographers. And, the Labor Department punished Time Life for doing that, even though we didn't have a problem with it, but that's a different story. So the way I understand it, so Gavin Newsom's signed the law. It's a law now. It's not just a bill. It's in effect. Is there any way to suspend it for this time, or is that's not even on the table?
No, it's not on the table. I mean, it's got to go through now the legislative process and be amended. It was really fast tracked. I mean,
Yeah.
the bill was proposed and passed in like August of 2019, signed by the governor in September of 2019, and the effective date was January 1st, 2020. I mean, that's usually effective dates 6 months or a
It's
year.
crazy. It's crazy. It doesn't happen like that, right?
And that was the thing also that just left us shaking our heads, because we had originally asked for a TRO, a temporary restraining order, and we wanted to do that right at the beginning of the year. And of course, the same judge who got what we think this part wrong, got that part wrong and said, well, you really should have brought this up ahead of time. Well, if litigation, the fact that the law got signed in September and took effect in January, we basically had 3 months in order to figure out who's going to work with us on this. We have pro se counsel. They're doing this in terms of, I should say, pro bono counsel. They're not getting paid for this because we don't have money. Everybody says, just sue. Well, nobody really thinks about the cost and the time, but we still had to put everything together and figure out whether we had standing, who was affected, draft the complaint, do all of those things. So this was done at lightning speed when you think about how long litigation normally takes. And a different judge in another court granted the truckers, who also challenged the law on other grounds, he granted their preliminary their TRO. And, it just really depends on, just like everything else. Some people get it and other people don't.
So I don't really know how this part of it works, but does it always stay in state court or does it bounce up to a federal level at some point?
So this was challenged at the federal
Okay,
level. Okay, I mean, it's a state law, but we were challenging it on constitutional grounds. So that has to be done in federal court.
great. Thank you. So, just I mean, by the time I first heard of this bill, the next thing I heard, it was a law. I mean, that's how quick it happened.
Right,
Just
exactly.
so, pour fuel on the fire, we have this constant, we're always under attack, uh, freelance photographers, for our copyright, whether it's work for hire agreements or just people using our work when they see it. And so what's the latest on that?
It continues. I mean, I think unfortunately, as the Supreme Court decision I told you about, it's certainly going to embolden states to feel that they can just take anybody's work and use it, and pretty much with impunity, until the Congress changes the law and says that they can, and does it in a way that comports with this latest Supreme Court decision in terms of what they can do to limit certain states' rights. But I deal with this all the time. I mean, I deal with lots of media lawyers, from all the major media organizations, and they're constantly complaining about being sued by the copyright trolls. And I push back is, first of all, you guys begat that. If it
You
the fact,
created the market for that.
if it wasn't for the fact that you were taking, and it wasn't just media. I mean, it's everybody who thinks that everything that's on the internet is there for the taking, that the internet is the public domain, when in fact that's a legal term of art, meaning it's something that's outside of copyright protection. But people, the more images that go up there, everybody thinks, right click, save as, do whatever you want. And, you know, unfortunately, no matter how much we've stressed it and told photographers they need to register their work with the Copyright Office, that doesn't happen. And, just last year, in another case called Fourth Estate, the Supreme Court said you can't even bring a copyright infringement claim unless that image has been registered. And so if you haven't registered before the fact, it's really not going to protect you. But even if you tried some other way to make some claims, until you get that work registered with the US Copyright Office, don't even think about filing a claim, because it's going to get tossed out at the very start. And we've seen that happen many times already. So there's just one thing after another as photographers continue to be squeezed. I'm constantly arguing, if you think there are a whole lot of copyright infringement claims, I don't think that has anything to do with trolls. I mean, a troll is somebody, as has been defined, as really isn't even interested in the work. Their business is putting stuff out there in the hope that somebody will take the bait, somewhat similar to the trolling idea in fishing, will take the bait so I can sue them for infringement, and therefore that's how I make my money, not making my money through the images I create. And that's not the case with most people. They have their images, they get paid by licensing their images, and far too many people think that they can just take those images and use them, and when they get caught, it's sue me, or it's fair use. I call it the FU defense, because oftentimes when you call somebody and tell them, excuse me, you used my work, they say, yeah, F you, and hang up. And fair use, again, is something to be determined by the court, and they have to go through that analysis. So, we've been working really hard on what's known as the CASE Act. We were really close. It passed the House pretty much with like a 410 vote to 6.
Nice.
It's been stuck in the Senate with one senator having a hold on it. And then all this happens, so everybody else is completely focused on that. But even that, I mean, you can't believe the beating we're taking from people, that think, again, that everything on the internet should be free. They're the same people that, if you look and scratch the surface, get their money from the Googles and other people that are making, trillions of dollars off the content that continues to float around out there, content created by photographers. And, the bottom line is, even with the Case Act, because of certain constitutional requirements, all the person has to do is opt out. It's that simple. If you get notice from the Copyright Office, should this bill be enacted, and somebody says, brings a claim, and it's claimants and respondents, not plaintiffs and defendants, but there's a cap on it, of 30,000 aggregate, 15,000 per infringement. I think most of our members are looking for a whole lot less than that. They just want, a reasonable amount of licensing. And what we're hoping for is, if this takes place, that it will start a conversation where somebody who, yeah, sue me, whatever, gets something and finally maybe pays attention, says, so what are we talking about here? How much money do you want? I'd like $750, or I'd like $1,500. Will you take, 1,000? That's the kind of reasonable negotiation we're asking for, as opposed to me having to tell people who've told me they didn't register their work, they really don't have any recourse. A copyright attorney is going to ask for a $10,000 retainer to bring an infringement claim in federal court, which is the only place you can bring a copyright infringement claim, is federal court. And it costs a lot of money to litigate that. $10,000 isn't gouging. It's the reality of what it takes, and all the discovery and depositions you might have to go through when a photographer is looking for that $1,500 licensing fee. Even if they win, they're going to lose, because so they win $1,500 and now they're in the hole, for the difference between the $1,500 and the $10,000, if they could even afford it. I'll give you the perfect example. In AFP v. Morel, which was the case where photographer Daniel Morel was down in Haiti, covered the earthquake. He lived there. He was the first one there, got these great images, pushed them out on the internet when Haiti's infrastructure was pretty much destroyed. There was no electricity. There was intermittent internet. He got those pictures out there. AFP and Getty took those images, thinking they had a right to disseminate them under the terms of service of TwitPic, which is what was in place at that time. Turned out that they didn't. If you look at the title of the case, AFP v. Morel, is they actually, AFP, Agence France Presse, sued Daniel Morel, seeking a declaratory judgment that he didn't have a right to those pictures, that they had a right to use them under the terms of service. Trial court judge said no. The next court judge up said no. Case ended up going to trial. I was at the trial. It was a jury trial. The jury awarded him $1.2 million, $150,000, which is the maximum for a willful infringement, times 8 images. His legal fees were $2.1 million. Now, fortunately, his attorney waived those, but it's just, you think, oh my God, 1.2 million, it's great, except that's what it took to get that verdict. So it's like, even when you win, sometimes you lose. And this is what we're facing. And this is what NPPA and ASMP and other organizations work so hard to try and advocate for photographers' rights on so many levels.
Is there any, 20 years ago, somebody told me, we had, I think it was a Nebraska Press Photographers Association event, this 25 years ago. They said, this expert in copyright law told us that whenever you push the button, the creator owns that work. Is there a way to ease the copyright procedures to make it easier for photographers to get copyright without having to go through? Is there?
Unfortunately, in many countries, as you said, the moment that something, and in this case, an image, is fixed in a tangible medium that can be conveyed to somebody else, something that somebody else can look at, the copyright vests with that person. What you heard was very true. Um, and there's always exceptions because it's the law, and there's always exceptions to law. If it's a work for hire, then it doesn't vest with the person. It vests with the person that you're doing it for. If you're an employee of a news organization, pretty much for the most part, as an employee, all the images that you take for them while you're working for them, they own the copyright to. But in the United States, unlike some other countries, you cannot enforce those legal rights unless you've registered the image with the US Copyright Office. That's the way it works in this country. That's copyright law. Now, there are certain things that help you, like in the case of Daniel Morel. He took those images, he put them out. They were published, on day one. He had 3 months, it's called a look back period, in which to register the work and get his copyright established from that first day. And so, yeah, there's that look back period that's helpful. But unfortunately, photographers just are not registering their images, whether it's too costly, whether it's too time consuming, it's not part of their workflow. I mean, we argued it used to be you could group register as many images as you want. Copyright Office just reduced that over our strenuous objections and comments that we filed to 750 images in a batch. Now, the one thing we were successful about is they wanted to have a double whammy of not only capping the 750 images to a batch, but also increasing group registration, almost doubling it. Well, we prevailed again in our comments, and they're keeping it at the same level. Not to say at some point they won't ask for an increase, but at least for now. But those are the kinds of things that we do, in terms of lobbying. But so many photographers, I mean, PPA dealing with wedding photographers. I mean, they're pretty much decimated by what's going on now because, people are canceling contracts left and right as their weddings are not going to be happening. So it's just across the board, not a good time for photographers at all. And then, in order to get these images that we're seeing from around the world, photographers are risking their lives and their health to go out and make those images and, hopefully do it on spec. Some of them are doing it as staff people, but I mean, they don't get to stay at home. You can't, dial it, telephone it in the sense of not being there. You've got to be there. Even a reporter can do an interview with somebody after the fact or with, whoever it is that they want as the subject. But photographers don't have that option, and we expect to have those images and see those images from them, and they're not just made by magic. Somebody is out there doing it.
Yeah, we can't phone it in. We have to be there, and that's always been the case. Us and the Marines. When there's gunfire, we run towards it. So, what you're well connected with NPPA and the PPA and ASMP. What are different organizations doing right now that you can share with us?
Well, we have a coalition of visual artists, and Alicia Calzada, who's the other attorney that works at NPPA, she's a past president. Are we up to some time limit here, or yeah, I'm not sure what that bell means.
No, that was my daughter texting me. She's a nurse, so she's
okay. Well, God bless her, and thank her for what
thank
you're doing. The daughter that's a PA, and a son-in-law that's a Miami-Dade firefighter. So yeah, we got lots of people out there in harm's way. So
absolutely.
So we have this coalition of visual artists, and Alicia and I facilitate those meetings. We meet weekly by phone. It's a number of organizations: NPPA, ASMP, PPA, APA. The Graphic Artists Guild, the North American Nature Photographers Association, DMLA. I mean, there's a number of organizations. And we've been working on the CASE Act all this time. Now it's probably going on two and a half years. But now we're all trying to do what we can to help our members in terms of providing guidance, advice, webinars. NPPA has a town hall meeting coming up on Wednesday night at 8 p.m. Eastern on Facebook. I'm going to be on it along with Chris Post, who's the chair of NPPA's Safety and Security Committee. We're constantly out there and trying to do what we can for members, understanding that, people are looking at their memberships and saying, all right, I got to pay the rent, or can I pay my membership? We certainly understand, again, that Hobson's choice, but we think that belonging to some organization so we can have this collective voice is just so important, whichever organization you belong to, as opposed to sitting around and just benefiting from all the work that we do. Kind of like, when you see the big fundraisers for, public radio, and you've been listening to it, but you don't donate to it. I think it's the same thing here, because I think we've been around, NPPA's been around since 1946. Everybody just kind of takes it for granted. But I think after COVID-19, all bets are off. We've never seen anything that compares to this. So whether there's talk about, will certain airlines still be in business after this? Will certain cruise lines be in business after this? I think there's a strong question that people need to think about. Will certain organizations still be in business after this? And as the voice of visual journalists, I think it's really important. I'm close to, if not past, retirement age. I'm one of the lucky ones. If I lose my job tomorrow and NPPA goes out of existence, my retirement fund has taken a huge hit, but, we'll survive. I'll be all right. But I worry for our profession, for photographers. I worry for the country in terms of what happens if all we have are government handout pictures, which I consider propaganda in the same degree as if they issue a statement that's untruthful. So I think, it's so important to have the code of ethics that NPPA has, that people that are members promise to abide by. So you're telling truthful stories and conveying accurate images and not hurting people by those truths that you're telling visually. There's just so much that's so important now. One of the things before all this, again, took place is, there used to be, and still is, don't believe everything you read, but seeing is believing. Now, we've already seen between Photoshop and all these other things that are now able to actually change even videos and have people saying things that they didn't say, but you're not going to know it. But we're seeing images that really are not coming from, where they're saying they're coming from, or they're not depicting what they say they depict. I think it's so important now to have those beautiful images there, so that when people do look at an image, the first thing they shouldn't think of is that real or is that fake?
Right.
It's good to have a certain degree of questioning, but it's really not a good thing when every image you look at and you wonder, do I believe it? It's the same thing as looking at certain news stories. You got to look at the source. You got to think about, who's behind it, who created it, and what kind of credibility they have. And that all comes from ethics, from professionalism, from so many of the things that are so important to us as photographers.
Yeah, news, the consumption of news for me, it's always been like buying fresh fish at the market. You got to check it out, see if it's actually fresh, if it's real, if it's all those
Right.
things. And the NPPA is one of those organizations that's been teaching and guiding us all for whatever, 60, 70 years, 80 years now. So thank you, Mickey. Thank you for filling us in. Thank you for the work you're doing. And everybody I've been talking to the last few days, it's not about just surviving this. It's about surviving in our community. That's what's going to get us through this and get us into the future, working together like we should be doing, like you said.
Yeah, I mean, as you know, I was a photojournalist in both print and broadcast for over 40 years. So for me, it's my way of giving back to a profession that I truly love and cherish. So it's really an honor to be doing this on behalf of NPPA and visual journalists and all photographers. So thank you for an opportunity to talk about this, and hopefully we'll just all get through it and can hold our heads up high for how we got through it.
Thank you, Mickey. We'll be tuning in Wednesday night, and we'll share that link below. Thanks
Great.
again.
Thank you.